Happy Easter, everybody. So I thought I'd do something completely different in this video, which might be really useful to lots of you as free guidance, not legal advice, you understand, but many of you might come across this sort of situation, maybe exactly this situation, but this kind of situation with lots of different products. And it's hugely frustrating when companies just give you nonsense responses and don't uphold your consumer rights. So this is something that it's really kind of irritated me, because you know that I'd traveled recently. Before we traveled, my fridge broke down and we had to, in a bit of a hurry, get a new one. Now, this is even more frustrating for me because I realized when shipping out the old one that it was still under some kind of warranty, because the website said it wasn't, but then there was some sticker on the back that said it was a 10-year warranty, so it should have been under warranty. So that was an argument I could have had but didn't have, because the website said it wasn't, the sticker said it was. It was registered, by the way, so all sorts of frustration. But that was the old one. The new one came in. Now, I like my fridge to be plumbed in to give me chilled water. I've always had that. I've had 2 or 3 of them. Hats off and sing the praises of Samsung, because I've still got this Samsung over here, which is now close to 20 years old. It did sort of start to break down, but then I fixed it just by defrosting it. Then it worked again. So I brought it in my studio here and it's going strong. So thumbs up to Samsung. Not so much thumbs up to LG this time. Now, I do like LG products. All my monitors are LG. My TV's LG. I really like LG stuff, but this one has let them down. You've probably guessed that the water dispenser is not chilling the water, and it should chill the water. In fact, the website expressly said as much. Let me show you. So the website says you can enjoy the luxury of chilled water on tap. Now, this is what we call an express term, which becomes part of the contract. It's a representation, which if is not true, then it becomes a misrepresentation if that's not true. And misrepresentation is one basis to form a breach of contract. Now, the response from them is quite ridiculous. I sent off an email to them perfectly normally, thinking that they'll sort it out, because surely this is just a simple problem that they'll either come out and fix, or if they can't fix it, they'll replace it, because this is brand new. The important bit of law, I'm within the first 30 days. So I'll explain all of that in a minute. The reason this will be useful to you is because if you have a similar situation, either with a fridge or a product or whatever, and the supplier says, nah, we're not doing anything about it, I will tell you step by step precisely what you do to claim and uphold your consumer rights to reject this product. And if it's faulty and you've rejected it and you go to court, you are likely to win, because if that defect is there and you reject it, they have to refund you. More about that in a minute. So I will spell out for you. I'll put in the description, if I forget. I might put it on my website, BlackBeltBarrister.com/ I think it's pages and downloads. I'll link that below. You have to register your email address or something, and then you can go to that page and download these documents. What I'll do is I'll put on there the Consumer Rights Act with the highlighted bits that I use as a lawyer day in, day out. These are the bits that I use. I've highlighted them all there. I'll explain them and I'll put that there for you. I will also do some kind of template as to how to fire this off to a company to say, give me my money back. Because when these problems arise and the companies say, no, we're not going to give you the money back, it's really frustrating when it's so straightforward as the fridge is supposed to chill the water. It's not chilling the water. You're supposed to repair it or replace it. Or in my case, because they refuse to do anything, I'm within the first 30 days, I'm going to reject it. So I'll tell you all about that. But first, let me tell you their response, because that's quite ridiculous. So I email them off nice and politely and say, this is not chilling the water. It's supposed to chill the water. I'd like you to repair or replace it because it's brand new. I've literally not used it. We fitted it. We went on holiday and then we came back and obviously realized it's not working properly, but we're still within 30 days. So here's their response. I've cut the name out, obviously, for privacy reasons, but they say, thank you for reaching out to us regarding the cooling performance of your fridge and the temperature of the water dispenser. The bit that I missed out in this is that, obviously I'm talking about the water not being chilled, but the fridge is also not chilling to the temperature that it's supposed to. It's supposed to go down to 2 degrees. We like it really cold, but it's only doing it to about 5 degrees because we've put a thermometer in there and the liquids and everything else are only about 5 degrees. Not good enough. So the unit itself is not chilling to the desired temperature, but the main bit for me is the water comes out at room temperature, like 15, 18 degrees or whatever. So here's what they say. We are here to assist you. Regarding the temperature of the water dispenser, especially in a plumbed-in unit like yours, It's essential to note that the water temperature is influenced by the temperature of the water coming directly from the tap. In other words, they expect it to be the same temperature as the water source, which is not true because that's not what the website says anyway. But then they said when the fridge water dispenser is used for the first to second glass of water, it may dispense cooler water, which it did, which is why we thought, nice and cold water. Subsequent glasses of water dispensed will reflect the temperature of the water source, and therefore it's not indicative of a malfunction. Really, LG, you expect the water in a water dispenser of a chilled refrigeration unit to come out at tap water source? Why would I not just use the tap? I literally have water on tap at the tap if that's all I want. If all I want is the water from the tap, which mine are filtered anyway, by the way, but if all I wanted was tap source temperature water, then I would just use it from the tap. But the whole point of having a plumbed in, and I went to the trouble to get this plumbed in, not much more trouble because the old one was plumbed in, so I connected it, you know what I mean? I connected the water source line. But their website says the luxury of chilled water on tap. If you've never had the luxury of chilled water on tap, you don't know what you're missing. You really do need that because it's fantastic. It does make the ice, I'll give it that. It makes the ice slightly smaller cubes than the previous one did, which is fine, I suppose. They melt quicker, so I prefer the larger ones, but that's by the by. But there is also a filter system inside the fridge, which is taking up a huge amount of space, which surely they could put some kind of unit in there to chill the water. Anyway, that's not the point. It's not doing what it's supposed to do. Their email said that it's not indicative of malfunction, and they expect it to be the same temperature as the source of the water, which I find frankly ridiculous. And it's a breach of contract because their website says it's chilled and it's not. And so anyone reasonably would expect it to be chilled. But even if that's not just relying on the expectation, the website says so. The website says it's chilled water. Now they say it's not. So it's both a misrepresentation and it is a breach of the Consumer Rights Act in that several things apply. So what do you do about it? Because my response to them has gone off already. And I was like, oh, okay, let's do it that way. Here's my letter. I reject it under the Consumer Rights Act. So I'll tell you exactly what to do here. And I will pull up the relevant sections here. So you have in the Consumer Rights Act, if you buy something online, let's go through the timeframes very quickly. If you buy something online, you have 14 days within which you can return it with no reason whatsoever. Just be mindful that you are responsible for the return shipping. It doesn't have to be in the original packaging, but they can make a deduction if you've used it and it's no longer saleable and so on. But if the website, so long as the website makes it clear that you're responsible for the return shipping, you're responsible for the return shipping. If not, then they're responsible. There's a few other things like that in the Consumer Contracts Regulations of 2013. So that's the first 14 days. Then the next time frame is the first 30 days. If it is not in accordance with the contract per all the reasons in the Consumer Rights Act, which I'll come back to in a minute, within the first 30 days, you have a short-term right to reject. Now, this is the one that really frustrates me, both as an independent citizen and as a lawyer, because companies try to say, well, our policy says something different. And my response is always, I don't care what your policy says. This is the law. This is statutory legislation. You cannot override these rights. These are rights. Now, as a business owner, it's also frustrating from the other side because it's like, they have the trump card here. They absolutely have the right to reject it if they say that it doesn't comply with the contract for various reasons. And if there's a defect, by the way, if it's within the first 6 months, it is deemed to be there at the beginning, and it's for the company to prove that it wasn't. And then after the first 6 months, that burden reverses. After the first 6 months, the burden is upon you to prove that it was there at the beginning. So within the first 6 months, it's deemed to be there at the beginning, and the company has to prove otherwise. So if they ship something out, you break it, they have to prove that you've broken it. But after the first 6 months, you have to prove that it was a defect that was there at the beginning. And more about latent defects as well. I've got another issue that I'm going to talk to you about on a completely separate matter. So I'll talk to you about that in another video, but let's stick where we are first. So first 30 days, you can reject it. You've got the short-term right to reject it. After the first 30 days, which is not my situation here, but briefly covering it, after the first 30 days, you have the right to a repair or replacement if it doesn't conform to the contract. And as I say, the burdens are in your favor for the first 6 months and they are against you afterwards. but you have a right to repair or replacement after that. And your overall time frame is 6 years. That's set by the Limitation Act. Apart from knowledge and latent defects and things like that, which again, I'll come on to in another video. So here we have in my situation, and so if you've got something, you bought something and it's just not right, you have 30 days within which to reject it. It is a right to reject, not just an option, not just a debate, not just a discussion with the company. You have a right to reject it under the Consumer Rights Act for the reasons set out herein. So under Section 20, you have a short-term right to reject, and the subject to bits here are the timeframes, and it's 30 days. The right is exercised if the consumer indicates to the trader that the consumer is rejecting the goods and treating the contract at an end. That might be, give me my money back. That might be something you do and say that indicates that you've rejected the goods. The indication may be something the consumer says or does, but it must be clear enough to be understood by the trader. So if you said, I don't want it anymore, give me my money back, that's good enough. So that is your short-term right to reject under Section 20. Now, why might you reject it? Now, many of you might know these already. Let's go through a few of these sections. So again, I've highlighted this act, so I can link this. I'll put it on my website somewhere for you to download. It's not to be taken that these are the only bits that are important. It's just the frequently referenced bits that I think are important. Section 9, to be of satisfactory quality. Now, there's lots of things that go into this, but essentially it is what an ordinary reasonable person would think it to mean. So it is an objective test, and the quality of goods is satisfactory if they meet the standard that a reasonable person would consider satisfactory, taking into account the description of the goods, the price or other consideration, and other relevant circumstances. The price might be important because let's say you've bought a high-end luxury branded car, which is very expensive. You can expect a higher level of quality, and this is what the courts have said and how the courts have interpreted it. The courts have said the more you pay for something, the better the quality it should be. If you buy a cheap T-shirt, and I'm not going to name any shops and embarrass them or anything like that, but if you buy a really cheap T-shirt and it's sort of frays and wears after 3 to 4 months, that's sort of to be expected. If you buy a high-end one for hundreds of pounds or whatever, you should expect it to last. I did some shopping the other day. I tend to buy expensive clothing for the most part because they last. So shoes and that sort of thing, the more you spend, the more you can expect from the product. So that's satisfactory quality. So the quality is something that comes into play here, but possibly more useful in this scenario I'm talking about here is the purpose and as described. Because fit for particular purpose. Well, if you plumb in water into a fridge, which is dispensing water, which is supposed to be chilled, and it doesn't do that, then it's not fit for purpose. So this is absolutely crystal clear, straightforward as it could possibly be. It is not fit for the particular purpose of chilling the water because it's not chilling the water. And this is also applies, by the way, which many people miss out, under subsection 1. If you tell the trader that it needs to do a certain thing, then it needs to do that certain thing. It's no good later them saying, well, I didn't know whether it really did it or not. I just told you that it did. If you say, does it do this? And they say yes, but it turns out it doesn't. They can't say, well, the manufacturer said no after all, so it's not my fault. It is their fault. So if they've sold it to you on the basis that you said it should do this thing and doesn't, that is their fault. Under sub 3, whether or not those goods are ordinarily used for that purpose, it's still to be treated as including a term that they are reasonably fit, whether or not they are usually used for that purpose supplied. So fairly straightforward. If it is not fit for the particular purpose, i.e. doesn't do what it's supposed to be doing, then it's in breach of section 10. Section 11, to be as described. Now, this is exactly the scenario here, because if we go back to the website, it says chilled water on tap. So that's describing what it does. So if it is not as described, it's in breach of section 11. Every contract to supply goods by description is to be treated as including a term that the goods will match the description. If the supply is a sample, etc., then it's to match the sample. And this also applies to any other pre-contractual information about the product, etc. So absolutely crystal clear. There are 3 sections there. The first one looking at the quality. Now, within quality, it does also touch on the fitness for all purposes that the kind are usually supplied. This is sub 3. The quality of the goods indicates the state and the condition and the following aspects, among others: appropriate cases of aspect of quality of goods, fitness for all the purposes for which goods of that kind are usually supplied. So refrigerated units with water dispensers are usually supplied with chilled water, and in this case it isn't. So certainly under that category there, I would say that it is not satisfactory quality. But also appearance and finish, freedom from even minor defects, safety and durability. So if you buy a brand new thing, it should be free from defects, it should have the appearance and finish you'd expect of a new thing, it should also be safe, and it should also be durable. So durability, if it only lasts for a few months, clearly it's not satisfactory quality, etc. So that is the first one. Second one, by way of recap, fit for the particular purpose. It's got to do what it's supposed to do. And if it doesn't, it's in breach of Section 10. And it's also got to be as described. So this is one that I've actually had a bit of a bugbear with courts about in the past, because as described, got to match samples and things like that. Beware of color fluctuations, because I've had one scenario over the years where this one that stands out in my mind, because I've really disagreed with the court respectfully on this one, in that the sample described was of a silver color. This was in terms of a type of stone, and lots of people on the internet had the same kind of issue, whereas the comparator was almost pink. So they were completely different. But the terms and conditions said the color may vary because it's a natural product. And the court upheld it. To my surprise, the court upheld that and said, yeah, they said that the color may vary. But I'm thinking vary from silver to pink? What's the point in choosing a color? So I disagree with the court respectfully on that one. I think that decision was wrong. But that's not a basis for appeal. You can't appeal and say, well, I think the court's wrong because the court's judgment is wrong. You can't appeal on that basis. You can only appeal if the facts are wrong, or the law's wrong, or there's a procedural error or impropriety in something, and that's not usually the case. But here we go. So now what do? Well, you write to the trader, the supplier, with whomever you've contracted to purchase this thing. And it is usually the person that you've purchased this from directly. So let's say you bought it from a shop. It's the shop that you have the contract with. It's them that you go to. If they try to push you to the manufacturer, that's wrong, because you bought it from the shop. They are responsible for the contract. Now, again, if they blame the manufacturer for, well, they say it doesn't actually do that, even though we said it did, that's just not acceptable either. As it happens, I bought this one directly from LG, so a little bit disappointed because it's directly from them. They say on the website that it does do this, and they say in the correspondence that it doesn't. So it's a quite clear contradiction to me. So I've written and said, well, that's disappointing. I reject it under my consumer rights, under these sections of the Consumer Rights Act, this, and this, and I've told them why. Your website says it's chilled, and you now say it isn't. It's not fit for the purpose. It's not as described. It's not satisfactory quality because it doesn't do what it usually would be expected to do for the kind supplied. Therefore, I reject it under Section 20 of the Consumer Rights Act. I'm within my first 30 days to do that. And therefore, you need to refund me. And that's under sub 15. If I scroll down, again, I've highlighted it for you here, and I'll give you this for free on my website. A refund under this section must be given without undue delay in any event within 14 days, beginning the day on which the trader agrees that the consumer is entitled to a refund. But to be clear, in your letter, you give them 14 days to respond, after which you can just file the claim. And I would also throw in there that you are aware that this is likely to be allocated to the small claims track, so you will not be at risk to costs if you lose the claim. You'll only lose the filing fee and the hearing fee and things like that, unless you do anything really wrong, such as you don't comply with the court order, or there's any kind of fraud in there, or you just don't follow the procedures properly. Then the court may punish you with regard to costs under CPR 2714G. They may issue costs against you, so there is that risk there, but it's highly unlikely. It's normally reserved for fraud. I've been successful many times in getting costs, even in small claims, because the other side's been fraudulent. In one case, they even had a Phoenix director for a company. This person didn't exist. It's outright fraud, and it was clear to everybody. So I've got costs in full on situations like that. So that's what you do. You write to them, you give them 14 days, and you hope that they see sense, because otherwise you're just left in this ridiculous situation of going to court and a judge saying, well, your website says it does this thing. You now say it doesn't. It's therefore not fit for that purpose. It's not as described. They have a right to reject it. you're supposed to refund them and didn't, why are we in court? That's where you would end up. But it will take, a year or whatever to get there, to get into court for this to happen. But I hope that's useful. Bit of a different video this time. A hugely frustrating situation, which many of you find yourselves in. Many people just accept it because it's too much hassle and everything else, and you just live with it. But I'm here to help you make that process easier. Just don't settle for these things when the website makes clear on one hand, but actually it turns out it's not the case. Because this is just ridiculous. But let me know what you think in the comments below. Please do subscribe to the channel. And as always, thank you for watching and happy Easter.